So I want to begin to thank all the organizers and all of you for being here. This is a great honor for me to present my talk, U.S. Feminist Legal Theory, Historical Roots and Modern Branches. I note this is a broad overview of the historical roots of feminism, but I'll launch right in. U.S. feminist jurisprudence is a philosophy of law based on the political, economic, and social equality of sexes. It draws, however, on feminist work from other areas of philosophy and thought. And in particular, it respects the feminist movements of other countries, which may not be based on equality, but are based on dignity theory. So when we look at the US, there are mixed opinions of when feminism began. Many track from 1848 and the Women's Rights Convention in Seneca Falls, New York. However, I like to date it back even earlier to Abigail Adams, the second First Lady of the United States, who was married to our second president, John Adams. She wrote to her husband in a letter, and I won't quote the whole thing, but she said in 1776, if particular care and attention is not paid to the ladies, we are determined to foment a rebellion and will not hold ourselves bound by any laws in which we have no voice or representation. So I note that from the birth of our nation that we have women fighting for equal representation and women's rights. Now, we also have the 1848 Women's Rights Convention in New York. The goal of this convention was to initiate activism more broadly than the style that Abigail Adams evidenced, to initiate activism and devise a cohesive agenda for social and legal reform of the state, family, church, and economy, basically every aspect of US life. Elizabeth Cady Stanton drafted most of the Declaration of Sentiments. And I won't go into great detail. Elizabeth Cady Stanton is under the red arrow in the picture of the organizers of the convention. I won't go into great detail of all the demands of the Declaration, but I'll focus on a few, particularly the right to vote, although it took another 75 or so years to achieve that right to vote in 1920. But they wanted changes in other laws pertaining to family, pertaining to employment and wages, education, even religious practice, and particularly freedom from domestic violence. Because in many locations in the United States in these days, husbands could physically discipline, i.e., abuse their wives. So as we look at the convention, this convention gave women many ideas, and one of the ideas was that they could themselves become lawyers. Now, one woman had already acted as a lawyer as early as 1648 in the colonies, but she hadn't officially become a lawyer or practiced under the bar, the Association for Lawyers. The first woman lawyer was admitted to the bar in the state of Iowa in 1869, and she began with a series. Yes, I see a hand raised. Is there a chat? Let me go back. I'm afraid I can't see the chat, so someone will have to chime in if I need to stop. So these women became lawyers arguing that they should have the right to advance the cause themselves. You have the first female Black lawyer, Charlotte Ray, in 1872. And following, you have many other lawyers who came in from disadvantaged backgrounds or from minority populations, Native American women, Latinas, Asian American women, and Vietnamese American women, who all came through the 20th century to advance the cause of feminism as lawyers. So operating as lawyers, we found through the 20th century that there were three schools of thought within feminist jurisprudence. There are many more, but I'll focus on three today. First, liberal feminism, and Ruth Bader Ginsburg is an excellent example of a liberal feminist. They believed that women were just as rational as men, they should enjoy equal opportunities, and they should reject the assumption of male authority. People should erase sex-based laws that disable women in the marketplace and in all aspects of US political and legal life. The second group were the cultural feminists. They focused on the differences between men and women and celebrated those differences. In particular, they recognized the importance of childbearing in legal, political, and economic status. Bell Hooks, while she is not a lawyer, she's actually a professor of philosophy and literature, she calls herself a cultural critic, but I raise her here because she came up with what I thought was a very powerful definition of feminism. Feminism is a movement to end sexism, sexist exploitation, and oppression. And I won't go through the rest, but you all will have access to my slides. She really encapsulates this notion of the differences in women should be acknowledged, and that not all women originally aspired to equality because, as Bell Hooks said, they are continually, particularly poor, lower class, and non-white women, were continually reminded in their everyday lives that not all women share a common social status and the privilege to access legal rights and opportunities. All right, so the third group focused on inequality. These were the dominant or radical feminists. Dr. Judith Baier, she talked about situation jurisprudence, where focusing on male domination and the inequality of women. The dominant feminists look at gender as a question of power. They urge the abandoning of traditional approaches to advancing the feminist cause. And they believed that equality had to be constructed on the basis of women's differences from men and not be a mere accommodation of those differences. I think perhaps one of the best examples of a radical feminist is Catherine Mckinnon, who wrote in numerous areas, but also she really perhaps was the mother of sexual harassment law with her book, Sexual Harassment of Working Women from 1979. She wrote that the inequality approach, by contrast to the differences approach of cultural feminism, sees women's situation as a structural problem of enforced inferiority that needs to be radically altered. So there were many common themes to these feminist movements. They all believed in the equal moral worth of all human beings under the law. There were criticisms of traditional views of the law and patriarchal assumptions as reflected in the law and of the problems that women have in securing equal justice under the law. And the use of legal realism, that is the notion that reality influences law, they use that to criticize the formalistic and male-biased approaches to law. Of these various schools of thought, you see particular feminist movements that were directed towards substantive change in the United States. Particularly, as I've mentioned, the women's suffrage movement, which got into full high steam in the 1880s through 1920. And as I mentioned, Elizabeth Cady Stanton and also Susan B. Anthony were among many women who finally advanced the cause and achieved the right to vote for women in the 19th Amendment to the United States Constitution, and particularly the Bill of Rights. Also, you have the progressive feminist movement from about 1890 to 1930. This movement was focused on bodily autonomy and sex rights. And I mention here Margaret Sanger, who advocated for contraception and women's health. She's the founder of a clinic that later became the Planned Parenthood Federation of America, which is still advocating on behalf of women's health and particularly women's reproductive health. And this is obviously a big issue in the United States, as on Monday, the United States Supreme Court will take up the new Texas anti-abortion statute. Also, we have the civil rights movement, which I date from 1955 to 1991. Many would say 1975, but I'll explain 1991 in a second. The civil rights movement really began as a movement based on securing equal rights for African Americans. But the Civil Rights Act of 1964 contained Title VII, which was an anti-discrimination in employment statute that originally applied only to prohibit discrimination on the basis of race. At the last minute, it was amended to include a prohibition of discrimination on the basis of sex. So the feminist movement was advanced by the civil rights movement generally. Rosa Parks really began the advancement and the notoriety of the issue by taking her place at the front of the bus. And I say that it continued through the 1990s because of Title IX. This is Title IX, the 1991 Education Act amendments, which secured rights for women and girls in education and sports, athletics. And so this was very important for advancing the feminist legal cause. Other women like Bernita Shelton Matthews, she was the first woman to serve on the U.S. District Court, but she led a committee of 13 women attorneys who were charged with studying the discriminatory laws of each state. So they went state by state looking for laws that posed problems for women. Polly Murray was also part of the civil rights movement, coined the phrase Jane Crow laws that particularly discriminated against women's African-American women. She was also the co-founder of NOW, the National Organization for Women, which continues to do important work advocating for feminist legal rights and advancing feminist jurisprudence. There are many more notable women, and I cannot tell all their stories. Anita Hill, who in 1991 accused and testified regarding Clarence Thomas and sexual harassment. He still serves on the United States Supreme Court, and she is still fighting for women's rights as a lawyer and a teacher. Gloria Allred also advances the cause for women as a lawyer. Stacey Abrams was important in securing voting rights in Georgia in this last election and has been working across the nation to continue that effort. We have a split, 50-50 split, United States Senate right now, in part thanks to Stacey Abrams, and it is Kamala Harris who casts the deciding vote in our Senate right now if there is a split and the vote comes comes to call. So Kamala Harris, as our vice president and the first woman, is also a lawyer who is active in California as the attorney general there. Lani Guinier was very instrumental in voting and politics. Kimberly Crenshaw coined the term intersectionality, emphasizing the importance of not viewing feminist jurisprudence only from the eyes of wealthy white women, but also taking into consideration racism, socioeconomic status, disability, and other factors which combine exponentially to change the legal opportunities and situation for women. Criminal law has advanced under women like Aya Gruber, family law under women like Martha Fineman, intellectual property law under my colleague Xuan Thao, who is also very active in Vietnam. So I want to recognize these women, Mari Matsuda, critical race theory, and Tarana Burke. She's not a lawyer, but she began the hashtag Me Too movement that I have been a part of. I show on my right my book, The Sexual Exploitation of Teenagers from 2016. I wrote about sexual harassment and exploitation of teenage workers and teenagers in school. I have another new project, which, because I'm running low on time, I won't go into, but I will just say special thanks to all of the organizers of this conference. I appreciate that you brought us all together. It's been an honor to be here. And I want to thank you all and urge you to have a terrific conference.
Thank you so much, Professor Jennifer Drobac, for your very, very interesting presentation.